Welcome back, dear students. Today we are going to learn how to draft the memorandum of first appeal. The question which is likely to be asked in the examination may be like this: draft an appeal from original decree under order 41 of CPC. Appeal from original decree means first appeal from the subordinate court to the next higher first appellate court. I have given you few references. You can pick up any one of these books for the purposes of drafting a memorandum of appeal from original decree or first appeal. So this is drafting of a memorandum of appeal from original decree under order 47 of CPC. Dear students, before we dwell upon the actual drafting of memorandum of first appeal, we must know the distinction between revision and appeal. As to what is the distinction between revision and appeal. You see, revision may be filed by the aggrieved party, or court can take suo motu cognizance of the revision, and revisional court can call the file of the lower court for revising an order of the lower court. This suo motu revisional exercise of power is available with the revisional courts, but this cannot be done in the case of appeal. Appellate court has no power to call the file of the lower court and start deciding first appeal, whereas it is possible in revision. Revision may be filed by the party, or the revisional court can take its cognizance suo motu. Why? The reason is that it is the duty of the revisional court to revise the orders of the lower courts. And revision is applicable. The jurisdiction of revision you can entertain, you can avail if no appeal lies there. There are three main grounds of revision. Dear students, you must know the grounds of revisions and grounds of appeal differently. So there are three grounds of revision. Number one, that the lower court has exercised a jurisdiction not vested in it by law. Suppose after creation of family courts, the Court of Civil Judge Senior Division has decided a divorce case. So lower court had no jurisdiction to decide a case of divorce because family courts have been created in that district. So this is the first ground where the lower court has exercised a jurisdiction not vested in it by law. And second ground of revision is that the learned trial court has failed to exercise jurisdiction vested in it by law. This second ground is reverse of first one. In the first ground, the lower court had exercised a jurisdiction which was not vested in it by law, and reverse of it is the second ground, that the learned trial court has failed to exercise jurisdiction vested in it by law. जो काम करना चाहिए था वो नहीं किया, और जो नहीं करना चाहिए था वो कर दिया. And the third ground, that the lower court has acted in exercise of its jurisdiction. Its jurisdiction is there, but they have acted with illegality or with material irregularity. Again, revision will lie. So these are the three short grounds on the basis of which aggrieved party can file a revision in the revisional court against the order of the lower court. And all these three grounds relate to jurisdiction error. Moving further, simple filing of revision does not operate as stay unless stay order is expressly granted by the court. In UP, the High Court has unlimited jurisdiction and district and session judges have jurisdiction of hearing the revision petitions where the valuation of the original suit was up to 5 lakh rupees. They are authorized to hear the revision petitions. And the test of maintainability of revision, my dear students, is where the impugned order. Impugned order means order which you are going to challenge in revision or appeal. So where the impugned order, if it had been made in favor of the revisionist, would have finally disposed of the suit or proceeding, then that order is revisable, otherwise not. For example, the lower court has taken a decision on issue of jurisdiction in civil and summoning order of an accused on criminal side. Suppose court has decided that they have jurisdiction to decide the case. You want to file a revision against it. Now reverse this order in favor of revisionist. That court had no jurisdiction. So once it is decided that court has no jurisdiction, then case is disposed of in favor of the plaintiff. So this order, when the court has decided the issue of jurisdiction, whether they have jurisdiction or have not, both the ways, the order is revisable. Similarly, on the criminal side, if I may talk, summoning order. Suppose court has summoned me in a case of breach of trust, and I wish to challenge this order before the revisional court. Now just reverse this order in favor of revisionist. Once my summoning order is quashed, I am acquitted. All proceedings will terminate in my favor. So order of summoning is also revisable because if this order was made in favor of the party filing revision, that would have finally disposed of the suit or proceedings. Now, dear students, as you know, we are to learn the drafting of memorandum of appeal today, and appeals are filed under Order 41 of CPC. So far as the first appeal is concerned, first appeal means appeal against original decree, and original decree means the first decree passed by the trial court. And second appeals are filed under Order 42 of CPC, that is second appeal against the decree. So my dear students, first appeal, which we are going to learn how to draft it, first appeal lies always on question of facts as well as law. And first appeal is the right of the party. First appeal is the right of the party. Meaning thereby that first appeal has to be admitted. When I was posted as district and session judge, the lawyers used to come to my court for arguing on the very first day when the first appeal is filed. I told them that first appeal is the right of the party and it has to be admitted. You need not come to the court and argue for the admission of first appeal. They were very happy. बोले साहब ये बढ़िया जज साहब आए हैं जो बिना सुने अपील एडमिट कर लेते हैं. Yes, when first appeal is the right of the party, it is allowed under CPC on facts as well as on law. So it has to be admitted. There is no question of hearing on admission of first appeal. But so far as second appeal is concerned, Second appeal lies only on substantial question of law formulated by the court. And then appeal is allowed from orders also, because so many interim orders are passed before a final judgment is pronounced. So appeal from orders are filed under Order 43 of CPC. And appeal from orders means appeal from those orders other than decree, and the orders are passed during pendency of the suit. Now, what orders are appealable and what not? There is a list of appealable orders which is given in Order 43, Rule 1 of CPC. Away from that list, no other order is appealable. Now, with this background knowledge in the mind, we will draft a memorandum of first appeal. That is appeal from original decree under Order 41 and Section 96 of CPC. So our heading today is Memorandum of First Appeal. Now, dear students, whenever you start drafting, the first question which comes to your mind is the name of the court. If the original suit was decided by Civil Judge Junior Division or Civil Judge Senior Division, the first appellate court according to hierarchy of courts in India, especially the state of UP, is the court of district judge. District and sessions judge is the first appellate court. When I am hearing a civil appeal, I will write down the name of the court as in the court of district judge, Noida, district Gautam Buddha Nagar, UP. And if I am deciding a criminal appeal, then I will write down in the court of sessions judge, Noida, district Gautam Buddha Nagar. Our designation is always double, joint designation as district and sessions judge. Thereafter, my dear students, you will draft civil appeal number dash dash of 2017. Here you know in which the appeal is going to be filed, but appeal number you do not know, because you are drafting this. You are drafting this first appeal or memorandum of the appeal while sitting in your corporate office. Now, first of all, you are supposed to draft the name of the parties. First of all, plaintiff appellant, his name, parentage, age, and complete address, and then likewise the name, parentage, and age and complete address of the other party also. So our appellant is A, son of B, aged about 40 years, resident of flat number 918 Pavilion Court 10, JP Greens, Fish Town, Sector 128, Noida, District Gautam Buddha Nagar. He is our plaintiff appellant. Plaintiff appellant means that same person was in the capacity of plaintiff in the lower court. Probably he lost the case. That's why he is coming in appeal as appellant. And the second party is X, son of Y, aged about 45 years, resident of flat number 509, Designers Park, Sector 62, Noida, District Gautam Buddha Nagar, UP. He is defendant, respondent. In the original suit, he was defending the suit, and in appeal also, he is now defending the appeal as respondent. Center heading, Memorandum of Appeal. Now you will start drafting like this. Sir, the above named plaintiff oblique appellant appeals against the judgment and degree of the Court of Civil Judge Junior Division Noida, passed in original suit number 34 of 2013-2017, dated 10/10/2017, whereby the suit of plaintiff for specific performance was dismissed by the learned lower court and sets forth the following grounds of objection to the decree appealed from. This is the opening sentence, opening paragraph which you are supposed to draft. Here you will write down the details of the judgment and degree and name of the court which passed the decree, suit number of the year and date of the judgment, whereby your suit for specific performance was dismissed by the learned lower court, and now you are going to file objections against that judgment and decree. Now you will write down the valuation of the suit was 20,000. Same will be the valuation of bill, that is 20,000. Court fee paid will again be the same as in the plaint. Now grounds of objection. What are your grounds? Straightway you come to the grounds. Para number 1, that the orders passed by the learned lower court are contrary to the provisions of law and principles of natural justice. This is the first ground of objection. Second, that the findings arrived by learned lower court are not supported by evidence on record. This is very important ground. You can take up this ground in every first appeal, every second appeal, even in the revision, that the findings arrived by the learned lower court are not supported by evidence on record. Third, that the learned lower court committed an error in holding the agreement dated 1/1/2017 was never entered into between the parties. And fourth ground, that the London lower court ignored the established principles of Indian Evidence Act and dismissed the suit of the plaintiff wrongly, disbelieving the secondary evidence produced by the appellant. Plaintiff has a right to give secondary evidence in the court if primary evidence is lost or destroyed or is in possession of other party. But the lower court has ignored this important established principle of Indian Evidence Act. Then para 5, that the original agreement to sell dated 1/1/2017 was lost due to theft in the house of plaintiff on 10th January 2017. See the reason why he is giving secondary evidence, because the primary evidence, original agreement dated 1/1/2017 was lost due to theft in the house of the plaintiff on 10th January 2017. However, appellant had produced its secondary evidence before the trial court. And regarding loss of original agreement, the appellant had filed FIR number 25 of 2017 under section 379 IPC. It should be 380, theft in a dwelling house, under section 380 IPC at PS sector 128 Noida. The police has now arrested the culprits, and the said original agreement was recovered from the house of one of the accused. It was released by the criminal court in favor of appellant, which has been filed before this honorable court during pendency of this appeal. You see, the reason which he has given is that the original agreement was lost due to theft in the house of the plaintiff. But later on, police recovered that original agreement from possession of one of the accused person, and then you can apply to the criminal court for release of the document to be filed in the civil case. So now you have the possession of that document. But when the lower court arrived at a decision, at that time you had given the secondary evidence before the court. Para 6, that the copy of the judgment and decree against which this appeal has been filed is attached herewith. It is compulsory in the first appeal to attach the certified copy of judgment and appeal along with memorandum of appeal. Para 7. That the learned lower court has having answered the first issue in the negative. Negative means there was no agreement, and decided the rest of the issues against the appellant, which is itself improper and illegal. Once there was no agreement between the parties, so the suit should have been dismissed on that ground alone, but the court has given finding on other issues which are against the appellant. Para 8. That the learned lower court has committed palpable errors while deciding the suit. And para 9. That necessary court fee is paid herewith. You are supposed to pay court fee once again in appeal. The court fee which you paid before the trial court gets exhausted when the judgment is pronounced. Now you want to file first appeal, you will have to pay the court fee once again. Against the judgment of first appellate court, if you want to go in second appeal, you will have to pay court fees again. And the lastly, you are supposed to draft the prayer.